Hi class, this is our recorded lecture on the Public Service Act. So the Public Service Act or Commonwealth Act number 146 was enacted back in 1936. So ever since then, this law has seen several revisions and amendments already. It has been so transformed that the original text of the law is unrecognizable already. So you should begin your study by reading the very recent amendatory law to the Public Service Act, which is Republic Act 11659. This was enacted in 2022. This only took effect on April 4, 2023, after the publication of its IRR. So I suggest that you just proceed with reading the IRR. The legislative history of the Public Service Act is discussed in the case of kapisanan ng mga kawani ng Energy Regulatory Board. So you'll see here that since 1902, the state has been regulating the operation of public services. So why do we have this kind of law? So the state recognizes the role of the private sector in national growth and development, and the state, in fact, encourages the private sector to invest in public utilities and public services. But in light of the nature of public utilities, which mainly cater to a public need, the state will still regulate this industry. But it will allow the private sector who operates public utilities to still have a reasonable rate of return in exchange for their capital investment. So what we'll be studying is the extent that the state allows the private sector to invest in public utilities, as well as the regulations imposed by the state in the operation of these public utilities. So in our Constitution, in Section 11, Article 12, okay, that lays down the rule, the cardinal rule in the operation of public utilities. So there is the restriction on the ownership of a public utility. Only Filipino citizens or Filipino corporations are allowed to operate public utilities. So that provision of our Constitution has been interpreted by the Supreme Court to, in fact, decree the Philippinization of public utilities. So our Constitution, okay, wants that public utilities be effectively controlled by Filipinos. Okay, but in the recent amendment to the Public Service Act, which was driven primarily to liberalize the public sector industry, you'll see there that there has been a policy to allow, okay, or increase private sector participation in the operation of public utilities. So how did they do that without amending the Constitution? So that was done through defining what public service and public utilities are. So only those that are enumerated or included in the definition of a public utility in Republic Act 11659 will have the restriction on foreign ownership. If not included in the definition of public utilities, then there will be no foreign restriction. So that's how the new mandatory law, okay, liberalized the Public Service Act. Because prior to this law, it was only the court who could define what a public utility is. In fact, it is in case law that we know what public utility is. So this is the first time that Congress has given a statutory definition of public utility. So in addition to defining public utilities, the Public Service Act is also characterized by the requirement of obtaining a certificate of public convenience before any entity can operate a public utility. So you'll see in section 13A the definition of a public service. So from that definition found in section 13A, okay, section 14 now enumerates the exemptions to the definition of public service. So the definition of public service has not been changed in Republic Act 11659. So Republic Act 11659 only defines public utilities. Because Commonwealth Act 146, it did not provide any definition of public utility, only public service. So matter of reading, guys, please read section 13A for public service. Question: is there a difference between public service and public utility? Is operating a public service equivalent to operating a public utility, and vice versa? So you find out what's the difference between the two. Considering the definition of public service in Commonwealth Act 146, does this transportation are these transportation network companies and transportation network vehicle services like the Angkas, the Grab, are they considered as operating a public service? So this has been decided in jurisprudence already. So TNCs and TNVS is considered equivalent to operating a common carrier. They are not private carriers. So this is the most important amendment introduced by Republic Act 11659. It gives us a definition of public utilities. So here there are only 6 fields or industries that are enumerated under the definition of public utility. So if not included in the enumeration, then that industry, that service is not considered as public utility. So the definition given by Republic Act 11659 is exclusive. So no other person is deemed a public utility unless there is a subsequent law that includes that person as a public utility. So in RA 11659, the NEDA can make recommendations to the president to have a reclassification of public services into public utilities when the criteria given under the amendatory law is satisfied. So what are these criteria? So please read it in the IRR. So what's the significance of the amendments introduced by Republic Act 11659? So as already mentioned earlier, it liberalized the Public Service Act. So prior to the amendment, the term public utility was defined only by the Supreme Court. And the definition given by the court was so encompassing and so broad that it included almost all key industries. So foreign ownership and foreign investment in those key public services was limited only to 40%. So this statutory definition of public utility will allow full foreign ownership, 100% foreign ownership to entities that were previously considered as public utilities. So what are these industries? Like, for example, the operation of an airport, it used to be a public utility. But since it is not included in the definition in the new law, then the operation of airports, okay, is now open for 100% foreign ownership. So other industries that are no longer considered as public utilities are subways, airlines, railways, expressways, and tollways. So if you take a look at the definition given by the Supreme Court, you'll see the point there that the old definition, the jurisprudential definition, was so encompassing. So the Supreme Court defines public utility as a business or service engaged in regularly supplying the public with some commodity or service of public consequence. So almost all key industries are covered by the jurisprudential definition of public utility. In fact, the Supreme Court has consistently ruled that the categorization, the characterization of a business or service as a public utility is a matter of judicial and not of legislative determination. So it will not be uh, uh, it will be easy to predict that this RA 11659 can potentially face a challenge, a constitutional challenge with respect to the power of the legislative department and that of the Supreme Court. So maybe that's why they included it in the syllabus, guys. So they'll be asking about it in the bar exam. So here are some judicial definitions of public utilities. Please read GG Summit Holdings versus Court of Appeals. So here, the term public utility implies public use and service to the public. So the principal determinative characteristic of a public utility is that of service to or readiness to serve an indefinite public or portion of the public. And the public, in turn, has a legal right to demand and receive its services or commodities. So it is not just a privilege to use these services or to avail of these services. It's a matter of legal right on the part of the consuming public. So the court has also given a definition of public use. So public use is not confined to privileged individuals but it is open to the indefinite public. So there can be no discrimination. If you are a part of the public, then you are entitled to receive that service if you demand for that service. In Republic Act 11659, the mandatory law, it made clear that a public service which is not classified as a public utility is considered as a business affected with public interest for the purposes of Section 17 and 18 of Article 12 of the Constitution. So what's the significance of this provision? So this means that if not a public utility, then automatically they are considered as of public service if they belong to the definition. And if classified as a business affected with public interest, then there can be temporary takeover of those businesses during times of national emergency, and that there can be a mandatory transfer of ownership to the state or to the public in the interest of national welfare or defense. So Republic Act 11659, okay, also introduces us to this classification of critical infrastructures. So this is a segment of public service which is considered as so vital to the Republic of the Philippines that if it is incapacitated or destroyed, then it will have a detrimental impact on national security. An example of this are telecommunications companies and such other vital services as may be declared by the President of the Philippines. So if a service or an industry or a business is classified as a critical infrastructure, then there is a restriction. In fact, a total prohibition against investments made by those acting on behalf of a foreign government or any foreign state-owned enterprise. So they are prohibited from investing in these critical infrastructures. The only exception are sovereign wealth funds and independent pension funds of foreign states. They can invest, but the requirement is that they cannot invest in excess of 30% in that particular critical infrastructure. So one safeguard of the law, so even though it liberalized foreign ownership of public utilities, there are still safeguards put in place by the mandatory law. One of these safeguard is that the president can suspend or prohibit, okay, any proposed merger or acquisition or any transaction or any investment in a public service if it will grant or result in control by a foreign owned corporation if it is in the interest of national security. The IRR of Republic Act 11659, it details how the review of those transactions or investments which may be prohibited or suspended by the president in the interest of national security, how that review is to be carried out. So the review will involve uh, evaluating the consequence of any proposed merger or acquisition transaction. So just read the IRR, okay? Matter of reading. So since the law took effect on April 4, 2023, then only those transactions or investments on and after that date, are governed by RA 11659. So the law will not impair vested rights or obligations of contracts existing prior to that effectivity date. So I already mentioned earlier that the Commonwealth Act 146 is already unrecognizable because it previously established just one centralized body to regulate all public utilities or all public services. It was the Public Service Commission that was originally conceptualized to regulate, excuse me. So the Public Service Commission that was established under Commonwealth Act 146 is now defunct, and its powers has been transferred to several regulatory agencies who have authority to regulate a particular business or service. Like, for example, the operation of water districts is transferred to the Local Water Utilities Administration. The regulation of water permit users are transferred to the National Water Resources Board. So Republic Act 11659 is recognizing the transfer of the powers of the Public Service Commission to the various administrative agencies. So it is the relevant administrative agency which has jurisdiction and power to supervise, okay, the relevant public service or public utility in accordance with its mandate. Right. So if any private entity will seek to operate a public utility, they must first obtain a certificate of public convenience. So this certificate is issued by the relevant administrative agency upon compliance with its requirements, but the power to grant franchises are legislative in nature. So the law, Commonwealth Act 146 as amended, does not preclude Congress from directly issuing franchises for the operation of public utilities. So it is in Commonwealth Act 146 that we find the requirements for the issuance of a certificate of public convenience. So the applicant must be a citizen of the Philippines or a Filipino corporation. The applicant must be financially capable of undertaking the proposed service and meeting the responsibilities incident to its operation. And the applicant must also prove that the operation of the public service proposed and the authorization to do business will promote the public interest in a proper and suitable manner. So in the case of KMU versus Garcia, the court emphasized that a certificate of public hearing, of public convenience can only be issued after the conduct of a public hearing. So the applicant must undergo the process, okay, spelled out in Commonwealth Act number 146. So there must be a public hearing every time there is issuance of a certificate of public convenience. Okay, but there are several businesses or services that will not require a certificate of public convenience. So you can find these exceptions in Commonwealth Act 146. So some principles in the operation of public utilities that were emphasized in case law. So public utilities, okay, in order to encourage private sector participation in that industry, they are allowed to impose reasonable rates for the services that they offer to the public in order for them to have a return on their investment. So the question now is, what do we consider as a reasonable rate? So Commonwealth Act 146 as amended, okay, has granted the power to administrative agencies to fix the rates that may be imposed by operators of public utilities. So it is the relevant administrative agency which has the power to fix and determine the fair and reasonable rates, charges, classifications, tariffs, and schedules, as well as the commutation, mileage, kilometrage, and other special rates that can be imposed by operators of public services and public utilities. So this is found in the text of Commonwealth Act 146. But there are factors to consider when fixing rates. In the fixing of rates and whether that rate yields a fair return to the operator, then the operating expenses will be considered. So this is discussed in the case of Republic versus Meralco. Another factor to consider in fixing rates is the property used by the operator in running the public utility. So these properties being used will be subjected to appraisal and evaluation to determine its fair value. And another factor to consider in rate fixing is that the equipment used by the operator must be used principally for the operation of the public utility. If it is not used for the operation of the public utility, but instead it is used principally and secondarily for the promotion of a private business, then the net profits derived by the operator will be considered in fixing the rates. So the rates that can be imposed by the public utility will be reduced since it is also earning income from a private commercial activity. Is ownership of the facilities dedicated to the operation of a public utility considered as a public utility? So in the case of Tatad versus Garcia, the court differentiated between the operation of the public utility itself and the ownership of the facilities. So it's possible that The facilities are not owned by the operator, but the operator is only leasing the facilities used in the operation of the public utility. So in that case, the ownership of the facilities will not be subject to the requirements of the Public Service Act. So those are the relevant principles in relation to the Public Service Act. So I hope you complete the reading assignment pertaining to this law and read the IRR.